Hey everyone, I am criminal defense attorney Sarah Sparkman. I'm based in Fayetteville, Arkansas, and the topic of today's video is, can someone get charged with and convicted of a DWI in the state of Arkansas if their blood alcohol concentration is below 0.08? Joining me today is our special guest, Deputy City Attorney Taylor Samples with the City of Springdale. He has been a prosecutor with the Springdale City Attorney's Office for about a decade. He prosecutes all kinds of misdemeanors, including a lot of DWI cases, and he is a certified law enforcement instructor in the state of Arkansas. Taylor, thank you for being here. How are you doing?
Hey, I'm good. Yeah, Sarah, thanks for having me, bring me on to talk about this subject.
Well, before we get started with our topic about DWIs, I will give a disclaimer to the audience. This video is just for information and education on the law in the state of Arkansas. You watching this video doesn't create an attorney-client relationship between you, the viewer, and us, the attorneys, and it's not intended to be legal advice. Also, Attorney Samples is a government employee. He and I are on the opposite side of cases. So him appearing in this video today is not an endorsement of me as an attorney. This is just some good information that we want to share with you all. So that being said, are you ready to get started?
I'm ready. Yes.
All right, so question of the day. Can someone get charged with and convicted of a DWI in Arkansas if their blood alcohol concentration is below 0.08?
Well, that's a good question. Yeah, and the answer is yes, they can. And it has to do with a breakdown of the DWI statute. So if you look at the DWI statute at Arkansas Code Annotated 5-65-103, there is a provision of an A1, and there's also a provision of an A2. Under one of those provisions, and I can't remember if it's A1 or A2, the law says it's unlawful to drive or to be in actual physical control of a vehicle if your blood alcohol concentration is 0.08 or higher. And I think traditionally speaking, that's what a lot of the public will think of in the context of DWIs. Now there is also a second sub provision of that statute that I just pointed out. It says it's unlawful to drive or be in actual physical control of a motor vehicle if you are intoxicated. In response to your question, and my answer was yes, that's where that comes in, that kicks in under the second provision of the person being intoxicated.
All right, so I am looking at the statute I printed out right now, not from the internet, but from a research system. So I'm looking at section A2, and it says a person can be punished for DWI if their blood alcohol concentration is 0.08. And there is a separate paragraph, A1, that says that they can be punished for DWI if they are intoxicated. So the way I read it is that 0.08 blood alcohol concentration and intoxication are treated as two separately defined things under the Arkansas statute. Would you say that that's a correct read?
Yeah, I think you're right in that. I think in recent years, as a matter of fact, I know the Arkansas legislature came out sometime in the not too distant past, 2 or 3 years ago, to say that DWI alcohol under the section is a per se violation. Help me out here, Sarah.
So strict liability, I think, is the legal term of art.
Yeah, strict. So DWI prosecution under the alcohol statute is strict liability. And it all went back to a case called Lika that came out in the not too distant past that talked about DWI in the context of prescription drugs, and it talked about a reckless mental state. So right, you have to, under the law, view those two subsections separately.
And kind of breaking down what strict liability is, to me, that means you don't have to intend to be a drunk driver to be convicted under Arkansas DWI law. To me, that means if you're on the road and you don't realize you're very drunk, you don't realize you're drunk, you could still possibly be charged and convicted of DWI. Do you think that that's kind of a good explanation of that?
Yeah, I think so. And I think especially when you look at the Lika case that we referenced, and having to do with prescription medication, I think the legislature wanted to put a reckless mental state on that, because given there will be some situations where medications maybe with prescriptions are adjusted, and so that's where the differentiation comes in.
So they won't give that same leeway whenever it comes to alcohol as opposed to prescription drugs.
Right. Under the .08 context. So under the essentially, when a person is being prosecuted under the subsection of being intoxicated, the statute also defines intoxication. So that's a good starting point, I think. Under that subsection, look at the definition of intoxication, and it's more of a totality of the circumstances approach.
So we've established that .08 isn't this magical number, and anything below it means that you're not guilty of DWI. There are some instances where your blood alcohol concentration doesn't meet that threshold, and you can still be charged with and found guilty of DWI. So Attorney Samples, I know that you have seen many DWI cases over the years. What are the types of cases that you see where someone has checked below a .08 and they still wind up being charged with DWI?
Well, gosh, that's a good question. And the short answer is, I mean, there's a big variety of those, and every case is fact specific. Yeah, what I like to do is to start out looking at the statute, and under the statute, intoxication is defined as influenced or affected by the ingestion of alcohol, a controlled substance, any intoxicant, or a combination of those to such a degree that the driver's reactions, motor skills, and judgment are substantially altered, and the driver constitutes a risk of injury to self or other people. So again, if you look at the beginning of that statute, it says alcohol, a controlled substance, or any intoxicant. So when you're breaking down what could somebody be impaired on, that's a great place to look. And there are a large variety of drug categories out there that that people will find themselves in court because they have an accident or get stopped, and through either observations from the officer, toxicology results, and whatnot, they find themselves under the influence and being charged with driving while intoxicated.
And from that definition under the state law, to me, I read that and I think that a lot of what's going to determine whether somebody reaches that non-.08 intoxication level has to do with behavior and decision making. And the more behavior that a police officer thinks that leads to think that a person is intoxicated, the stronger of a case that the state will have against somebody who has been charged with DWI. Yeah,
that's right. I think there's going to be a number of factors that come into play. First of all, what was the nature of the driving what was the nature of the police contact in the first place? Was it the result of a traffic accident? Was it the result of driving that was observed by the police officer of traffic violations or otherwise poor driving? Was it the result of a citizen call-in complaining on a driver that they observe out there on the road? So that's the starting point of the case. Then the middle point of the case will be officer contact with the driver and the driver's reactions, the driver's responses to field sobriety testing performed by the officer if the officer deems that necessary. And essentially, you just look at the case from beginning to end there and see how it adds up.
So what I hear is that a lot of the decisions that an officer will make and that a prosecutor will make in deciding how they're going to move forward with a DWI is very fact specific, and no two cases are going to look alike.
That's absolutely right. Yeah, I couldn't say it any better than that. Now, going along with that, in Arkansas, the DWI law is written in such a manner that says there shall be a finding of guilt or not guilt on the charge. So once a person is charged with DWI, then that really limits what can be done with the case once it's in the system. It can't be amended down to a lesser charge. You're stuck with that DWI charge.
Yeah, that's a great point that you bring up. I once heard a district judge in East Arkansas say this, and it's a little bit of hyperbole, but it's not that far off. And she said that it is easier to get a murder charge dismissed in Arkansas than a DWI charge, just because under the law in Arkansas, a prosecutor has the ability, I don't think it happens too often, but to null pros a murder charge or to reduce it down to a lesser charge, whereas you as a prosecutor don't have that option with DWI because of the way the law is written.
Right. That's true. I think you may have somehow alluded to this, and I don't know if I addressed it. I know that there can be the idea out there among the public that if it's a DWI drugs case, it's got to be illegal drugs, a drug that, I don't know, cocaine or marijuana, for example, all the methamphetamines. While that's true, a person certainly can be charged with DWI for being intoxicated or on those drugs while driving. There's also the prescriptions. It can be a validly written prescription of any number of sort, that if the person gets behind the wheel or is in control of the vehicle and they're unsafely able to operate that vehicle as a result of being on that medication, and that's essentially what the evidence shows, then that person can be convicted of DWI.
I think that's a great point. And although that this is not an advice video, I would just tell people in general, if your medical provider has prescribed a prescription drug to you, especially one that has to do with pain management and mental health management, it wouldn't be a bad idea to ask your medical provider about the effects it might have on you driving. Because that's good information to have, and just know that it can be dangerous to get behind the wheel if you have a prescription drug, even if it's lawfully prescribed to you. So I would recommend having that conversation, and that's going to be the limit of my recommendations that I have in this video.
Right. No, and I think if there's even one person out there that can just hear that piece of information, and as a result of knowing that, will decide, hey, I'm not going to drive. I'm not going to drive now. I didn't know that. Wow. Um, and somebody then decides not to drive as a result of that, then I think that's a very worthy thing. And I'm glad that person knows that.
Well, attorney samples, we had talked previously about DWI cases being, very fact specific. And we had talked about prescription drugs. So given that a lot of this is fact specific, I've written up a couple of hypothetical scenarios. I'm hoping I could read those and ask you a few questions about that.
Sure, go ahead.
All right. So hypothetical number one. Someone gets into a one-car accident. So there's one driver in the vehicle, no passengers, no other vehicles. The police come out to respond to the accident, and the police think that the driver is impaired. The officers do all 3 field sobriety tests, the standard ones that we see in this area. And the driver of the vehicle is taken to the station. They are arrested on suspicion of DWI. However, they check a 0.07 on the breath test. So a breath alcohol concentration of 0.07. Can this person be lawfully charged with DWI?
Yes. The person can be charged with DWI. And I think what people need to understand out there as well, in order to be charged with DWI, it's like any other crime, there has to be probable cause of that violation. And probable cause is much less than the standard of beyond a reasonable doubt that's needed to convict in criminal court. Probable cause is essentially, is it reasonable for an objective police officer to believe that the crime has been committed? And going back to one of the first things we talked about here today, the second part of that statute that talks about intoxication, and then you look at the definition of intoxication of alcohol, a controlled substance, or any intoxicant, someone being under the influence of those to such a degree that the driver's reactions and motor skills and judgment are substantially altered, and the driver constitute a risk of injury to self or others. Well, the driver who has just found himself or herself in an accident, and then officers have evidence of that, that person could very well, yes, be charged for DWI.
So we've established that there is a difference between proof beyond a reasonable doubt and probable cause. So we've got a higher standard of proof that you, the prosecutor, have to reach to be able to have somebody convicted of a DWI. First of all, is it possible for someone to be convicted of a DWI if they reach a 0.07 on the breath alcohol test?
It's possible. It is possible. Now again, it's, as we've stated, I think a couple of times here, it's very fact specific. Looking at the driving, how bad was the driving? Looking at how the person did on the field sobriety testing out at the scene. Looking at just general observations that may be picked up by the police officer, even on body cams, video, things like that. And once the person comes, if they're at that 07 level, depending on how that testing goes and those factors, yeah, absolutely, it would be possible for a DWI conviction under those certain circumstances.
And I'll just interject here. You brought up body camera video. Just given both of our histories in criminal law, body camera has really been a game changer in the area of criminal law, I think, because as opposed to, relying on the word of the officer previously, or maybe some grainy dash cam video, we now have videos in high definition where we can see the behavior of all people involved. And so both the prosecutor and the defense attorney really have to take a look at that ahead of going to trial to make determinations on how strong a case could be.
Yeah, no, I don't disagree with that at all. It's certainly something that over the last couple of years here is becoming more and more prevalent in law enforcement.
Well, we've established that you can be charged with DWI whenever you check a .07, possibly convicted, depending on the circumstances. Let's change this fact pattern a little bit. So we've got the driver in a one-car accident again. The police come out, they think that the driver is impaired, and the driver fails 2 out of the 3 field sobriety tests. There is no alcohol in the person's system. They take a breath test and shooting zeros, as we call it, they check 0.000 on their breath alcohol concentration. However, the driver admits to taking a prescription drug called Klonopin 2 hours ago, and the Klonopin is not lawfully prescribed to them. Can this person be lawfully charged with DWI?
Right. Yes. Again, the person can be charged. When you look at the accident, you look at the reason for the police contact there in the first place. You look at poor performance on 2 out of 3 field sobriety testing, and the admission of the drug that you referenced there. Yes, the person could very well be charged.
All right. And I'm assuming that it's possible they could be convicted as well, given what we have gone over under the Arkansas statute.
Right. And again, there would be certainly under those circumstances, if that were truly the case, there would be, as we just mentioned, a bunch of other factors and details in the middle there to be looked at. But yeah, certainly a possibility of conviction.
And we touched on this previously. In this scenario that I gave, this person was not lawfully prescribed Klonopin. Would it make a difference if this person was lawfully prescribed Klonopin?
Yeah, that's a good question. Maybe, and it would go back to, we had touched on it earlier when the Arkansas legislature, the Leakey case came out a few years ago, where the Supreme Court said in that situation you described there, prescription medications, there has to be a reckless mental state for a DWI to carry. So we're out of that strict liability category of the 0.08 or higher. Now, what I've seen, there haven't been a whole lot of cases that have come along after to flush out that reckless standard. But that would be another factor to look at under the scenario that you just brought up of the prescribed medication.
And I would just say that it certainly would be an interesting thing for 2 lawyers to argue about in court, just because the case law is not entirely fleshed out as to that type of case. And
right.
So I agree. So I gave 2 fact scenarios, and both of them had to do with a motor vehicle accident. I'll just say it's pretty clear that when there is a motor vehicle accident in Arkansas, that police can investigate it. That's written in the law.
Yeah.
Does a person have to violate any traffic law in Arkansas to be able to be charged with a DWI?
Well, that's a really good question. And no, the person does not. As many people likely already know, the reason for a vast number of police contacts are because the police may pull the person over for speeding or left of center, a traffic violation, which would be a traffic violation, the reason they're pulled over. But there are also times whenever the officer doesn't observe a traffic violation, maybe in the context of a caller calling about the bad driving, and as a result, police getting behind the car and stopping them. Also, maybe as the result of the police officer following a vehicle, for example, that is weaving within the vehicle's own lane and driving at a slow rate of speed. That was a specific case that had come out a number of years ago where a car was stopped based on those facts of weaving within his own lane plus slow speed, neither one of which are traffic violations, but the stop was upheld as a result of the officer's decision to pull the car over to basically check on the status of that person. Reasonable suspicion of drunk driving would be the I guess legal term of art. So to answer your question, no, it doesn't always have to be a traffic violation observed by the police officer that results in the car being stopped.
So I'm hearing, just as we described in determining whether a person can be charged, whether a person can be convicted, we have a lot of facts to look at in determining whether somebody can be pulled over for DWI. And again, it's not necessarily a traffic violation that can get somebody lawfully pulled over.
Yes, yeah, that's right. Number of factors throughout essentially the whole process, from the initial encounter to the middle of the encounter to the end of the encounter. Just a number of things to be looked at.
So I remember in the beginning of law school, we were told that we would learn to answer "it depends" to a lot of things throughout our legal career. And I think through our discussion today, what I've taken from it is, the answer to a lot of our questions is it depends, and a lot of it is fact-based. But keeping that in mind, it is possible to be charged with a DWI if you check below a 0.08 on the breath alcohol test, and it is possible to be convicted depending on the facts of a person's particular case and their particular encounter with law enforcement.
Yeah, yep, that's right. I think that's a good way to summarize it.
Well, Attorney Samples, I really appreciate you taking the time to talk to me and the audience today. Is there anything that you want to add before we go?
No, I don't think so. Yeah, and thank you for giving me the opportunity to just put some information out there. Always happy to do that.
Well, thank you again, and thank you to the audience for watching. If you like the video, give it a thumbs up. You can leave a comment, and I will leave a link to my website in the comments. So until next time, we will see you soon.